My lord, if I will mention item number 5.
Item 5, yes.
I may be allowed to withdraw this petition, Your Lordship,
Okay.
upon the instruction of my client.
Mr.
P. Ronia, petitioner.
P. Learned counsel for the petition submits that he has an instruction to withdraw his petition. Therefore, phrase for withdrawal of the same. Who else are appearing? State.
Yes.
And Mr. N. Ratan London additional bucket for the state is present. Accordingly, it stands closed on withdrawal.
Oblige.
Your Lordship, I'd like to mention item number 12.
12.
Yes, Lordship.
Yes.
The consent has been taken from the other parties. This matter will be listed after 4 weeks. Lordship.
Why? For what?
Lordship, this matter is also pending at Supreme Court, Lordship. Yes, Lordship.
On the prayer, Mr.
Kegao.
Kegao.
Yes.
Kegao.
Kegao. K.
Your name is there?
No, Lordship. I'll be filing additional Wakalan
Kegao. Kegao, Learned counsel appearing on behalf of Mr. A. Tatak.
No.
Counsel but the petitioner.
T. Tatak. I'm for the respondent number 6, Lordship.
Okay.
T. Tatak. I'm appearing on behalf of T. Tatak.
T. Tatak, Learned counsel. Appearing on behalf of Mr. T. Tatak, Learned counsel for respondent number
6.
6. Praise for listing of the matter after 4 weeks. Praise the Lord, list after 4 weeks.
Oblige.
May it please your Lordship?
Yes.
Lordship, I'm sorry, Lordship, for mentioning to official Lordship, but Lordship, I'm praying for listing of the election petition 7/2024 on 27/05, Lordship. It was earlier fixed on 28/05, but the 28th has been declared as holiday. Can the matter be listed on 27/05, Lordship? On the coming witness?
Can the witness come on that day?
Yes, Lordship, the witness can come. He's ready to come on that day. I have informed the other side also.
Yes. You give the
Thank you. Highly obliged, Lordship.
27.
Highly obliged.
May it please your Lordship? Your Lordship, I beg to mention item number 28.
28.
Yes.
Yes.
I'm appearing on behalf of leading counsel Mr. M. Bagra, of petitioner. Due to leading counsel's father serious medical condition.
Actually, this matter was listed on the insistence of Mr. Bagra.
Yes.
Anyway, it is submitted by Mr.
P.L. Laya.
P.N.
P.L. Laya.
P.L. Laya.
Yes, L.E.Y.
Appearing on behalf of Mr. M. Bagra, Learned counsel for the petitioner. That Mr. Bagra, Learned counsel, has some personal difficulty, therefore fresh for listing of the matter after 2 weeks.
No, my lord, on 1st June.
After a week.
After a week.
On 01/06/2026. Yes.
Much obliged.
My lord, I beg to mention item number 29.
29, yes. Yes.
Yes, my lord. I've informed the opposite counsel, my lord. The respondent number 3.
Who is for the petition?
Come up after 2 weeks, my lord.
What? Who is for the petitioner?
I have taken consent from the petitioner, my lord.
Represented by Adam Tatak.
What remains here?
As informed by
my lord,
they want to file additional affidavit.
Who?
Respondent.
My lord,
respondent.
What happened? My lord, what happens that the project under construction, as per the verbal instruction, has completed about 90-25% of the work. So, my lord, we put that by affidavit through the status report, my lord. So, my lord, may kindly have it after 2 weeks of final disposal, my lord. We'll put that on affidavit.
On the prayer of Mr. N.K. Learned counsel for the respondent number 3.
Respondent number 3.
Respondent number 3.
Yes, my lord.
For the 2 weeks time is granted to file an affidavit, file an additional affidavit regarding the status of the works. List after 2 weeks.
Macam like.
My lord. My lord, if
Please,
it can be
sir.
given, my lord.
After 2 weeks, you just give them.
Eight June.
8th of June. Yes, next.
Lordship, I beg to mention item 13, Lordship. Matter become infructuous, Lordship. So,
13.
Lordship, I close the, yes.
1-3.
1-3.
Mr. K. Lolet, the counsel for the petitioner, submits that writ petition has become infructuous. List accordingly. Writ petition stands closed on having been become infructuous.
Deeply obliged.
Item number 1.
My Lordship,
Yes.
I beg for item number 18. Your Lordship, here we have to file rejoinder in response to the additional affidavit file response number 5. So we may be given some time to file the rejoinder.
This will be the compensation not under the 2013.
Your Lordship, I have instructed to seek time, so I didn't wait through the file properly.
This should be under the Electricity Act only, not under the 2013. Anyway,
My lord, I'm
MS?
there for respondent number 1, 2, 3, my lord.
any objection?
No, my lord.
Any objection?
No, my
Okay,
lord. The only thing
Mr.
is that, my lord, the maintainability
MSD
of the
Somo,
rent-
learned counsel for the petitioner. Praise for and is granted further 3 weeks time to file affidavit in reply. Mr. N. Kera, T. Marga,
T. Marngar, my lord.
learned counsel for the respondent number 3 is present.
My lord, only
Yes.
one prayer, my lord, if the question of maintainability may be kept open on the next date, my lord.
It's already there. You can raise it.
My lord. On my lord.
Item number 2.
Lordship, last time I could not satisfy this honorable court, Lordship, because of one.
Item number 1, actually, Lordship, she asked for the adjournment of item number 18 and 19.
Then you said 18, in item number 18 and 19. I thought it's 18 and 19, huh? 18 and 19. The Tisamo, huh? In 18 and 19. Not item. Yes, item 1.
Item number 1.
Non appears for the prisoner on call. Who else are appearing here? Item 1.
Item 1, Lordship.
Item one.
I'm
You
My lord,
also
I
like-
corresponded 1, 2,
Fine.
and 3 in item 1, my lord.
Mr. T. Marga, learned counsel for respondent number 1.
2 and 3.
3
1,
and
2,
4.
and 3, my lord.
1, 2,
1,
and
2,
3.
and 3.
And
I'm for 5, Lordship.
Land Standing Council, Power Department for respondent number 4, and as well as Senior Government Advocate for respondent number 5 are present. It appears that the petitioner is no longer interested to pursue this matter. Accordingly, this petition stands dismissed for non-prosecution.
Item number 2.
Lordship.
How long you'll take?
Lordship, only I have two judgments, Lordship.
What judgment?
For lapse and
What judgment?
Lordship, it is if land is
If the land is
taken by the authority without the acquirement, it deemed to be acquired, Lordship. That if land is possession of the land is taken by the authority without acquisition.
how do we know the position is with them? They have said only 300 something square meters have been acquired from you.
Lordship,
Not more than that.
Lordship, that
Or that they have already paid.
Lordship.
How do we know that they are in this position or not?
And Lordship, if there is a this word that
You go to civil court in
Lordship,
that case. If you are disputed facts, they are saying that they have only acquired 3,490, something like that. Right, madam?
Yes, Lordship.
And for that, the payment has been already made to you.
and yes,
That's
Lordship.
all. You are
Yeah.
saying that you have only 17,000 square meters.
Exactly,
There
Lordship.
is another position. There's nothing on record to show that there is another position. Are you saying that you are in position of 1,700 square meters?
Exactly, Lordship.
No, Lordship, in my para 4, we have clearly said that the land, his land is private land measuring 17,900 square meter has not been completely acquired, rather an area measuring 6,980.90.
That too, including one more person.
Yes, one more
Exactly,
person,
person.
brother.
Which is not,
Lordship,
he's not concerned. She's not concerned.
has only been acquired.
No, Lordship, now question is, now 17,000 fall under the
Which is disputed. Therefore, we cannot enter.
Lordship, even
Or
advance-
will you withdraw it, will give you a liberty to approach the appropriate forum.
Lordship, even advance payment for the
Doesn't matter. They are gracious enough. They have acquired the 3,400 something square meter,
and Lordship,
and in favor of your brother or relative,
yes,
another
Lordship.
3,000 something. That's all. They have already paid. If they have paid you more than what they have acquired, they are
Lordship,
gracious enough. You be happy.
one documents of the authority, state authority, Lordship.
Saying
that
what?
it is state that acquire land 99,462, and that include the
No, we don't know.
Lordship. This is not concocted. This is later communicated by the
99,000. It's not only yours is only 17,000.
yes, including my
Huh.
arithmetically, Lordship.
We don't know. We cannot. Sitting in a read court, we cannot.
Lordship, if I this allow to submit and show some documents also, Lordship.
What documents?
Lordship, they have not denied the possession of the 17,000, Lordship.
Huh?
But only they have not denied the dispossession of the 17,000 from
Yes,
the
sir.
Lordship.
What do you say?
But our part is
Are you in possession of 17,000 square meter?
Malad, to that extent, Malad, my affidavit is not very clear, Malad. We have already deposited the amount, Malad.
Huh.
You know, Malad,
12 crore.
12 crore and above, Malad.
You bring on record. You bring on record whether you are in possession of 17,000 square meter of land belongs to the petitioner. Can you find out?
Admittedly, Malad, that extent, Malad, our affidavit is silence.
As per LPC, Lordship, as mentioned by as per LPC, Lordship, 17,000 as per LPC.
Other day, I indicated you may have thousands of acres of land. What matters is how much area they have authorities have acquired. That has to be paid only. Why only 7,000 square meter? You must be having much more than that also. We are not concerned.
Lordship, this total area acquired without counting the 17,000, it does not count the total acquired.
It's become disputed. We don't know. What they have acquired is 3,000 something, 6,000 something,
Yes, Lordship, 6,000.
including your brother, who is
Yes.
not before us.
Lordship.
And that amount has been paid already. And you have accepted that.
Yes, Lordship. Only this condition that remaining is
You approach the authority, then come back, then they'll find out whether there's, because we cannot just, on your asking, we cannot.
Lordship,
Now it's become a disputed.
Yes, Lordship. Now the question is whether they are accepting this 17,000 is under possession of the ITBP or not. This is question, Lordship.
Okay, heard Mr. G. Kato, learned counsel for the petitioner. Next para. Having considered the claim of the petitioner that the length measuring around 17,000, exactly
900.
17,900
Yes, Lordship.
Square meters
Square meter, Lordship.
belongs to the petitioner is under the illegal occupation. Although the acquired area is of 3,000
3,490.
90.95 square meters, for which the payment has been made to the petitioner, Mr. M. Kato Lanet DSGI is directed to bring on record whether the ITBP
Yes,
is under the possession of is in the possession of 17,000 square meters of land in total, in addition to the
No, Lordship.
no, including the land already acquired. Mr. The affidavit is directed be filed on within 2 weeks. Within 2 weeks. 2 weeks you can file. Simply you have to show that if you are in occupation, you'll have to pay. Is not it? Because as per record, it's only 3,000 something.
Specifically, as per the affidavit filed by the ITBP, it has not been clearly mentioned. But
That's why I would like to know whether you are under possession of the
Para
entire
7.
17.
Para 7.
What does it say?
It says, it is altogether,
92,000.
462 square meter
Hmm.
of land given the meter. The DLRSO and the Deputy Commissioner has intimated.
Can you clarify?
That has been handed over to the ITBP. We have the Lordship document. That much, 99,462 square meter has been.
In fact, it's purely disputed. We are not able to make out anything. Anyway, list after 2 weeks. We'll see.
Obliged.
Item number 3.
May it please, Your Honor. Your Honor, this item number 3, notice was issued. Then subsequently, the sole respondent has filed their reply on Friday. I am seeking a week's time to file my rejoinder. A week's time, Your Honor.
What they say? What is their stand?
Their stand, they have given some allegations. We need to file our affidavit.
Not allegation, Lordship. One issue that is involved in this case, Lordship. Whether in their contractual agreement, that arbitration clause that they are claiming, that arbitration is there or not, Lordship. That issue has to be better.
Or is there any arbitrable issue?
Yes, Your Honor. That is it. Can it be on 2nd of June, Your Honor? Within a week, I will file it. Maybe taken about 2nd of June.
Okay. Mr.
K.M. Mohanto.
A.
K.M. Mohanto.
K.M. Mohanto, counsel for the petitioner. Respondent is granted a week's time to file affidavit in reply to the affidavit in opposition filed by the respondents. Next para, Mr. Judge in learned counsel for the respondents.
Yes,
all respondents.
For
the respondent is present. List accordingly on
2nd of June.
02/06/2026. Yes.
Deeply obliged. Deeply obliged.
Obliged, Lord.
Item number 4.
Have you filed the affidavit? Are you disputing?
Here, my lord, I have received the instruction from concerned E, my lord, as per his instruction, the amount is not disputed, my lord.
Then
But then, my lord, when I send this for law betting, my lord, the competent authority is raising some issue, my lord.
what is
So issue in here. So accordingly, we are contemplating some inquiry before filing affidavit, my lord. Proper affidavit, my lord.
you verify and we'll direct you to if he's found entitled, you pay it.
That can.
Heard, Mr.
But I'm informed, my lord, the concerned authority is contemplating some inquiry before filing, my lord.
You do whatever you want to do. You verify, you make an inquiry, whatever you want to do it
Yeah.
within the timeline.
Well,
Then if you found that, if it is found that he's entitled, you pay. If he's not, you reject it. What's it?
but then this instruction, my lord, let me.
This may be recorded, my lord.
Instruction I have read.
As per the instruction,
But I send this for law betting on my lord, second, my lord. But as the issue, my lord, here is some peculiar issue involved, my lord.
Peculiar. How peculiar? Either
No, my lord.
it is disputed or not disputed. What's the
Concerned
question of
authority is not
peculiarity?
disputing, my lord. But issue involved
What
is
is the question of peculiarity?
peculiarity, my lord. My lord, see, my lord, this work order was issued in terms of some minor meeting, my lord, 10/1/10/2020, my lord.
2020.
Due to some emergency, my lord. Now, work order, my lord, is of 2024, my lord. Now, that's why, my lord, how, my lord, if that way have some urgency, my lord, after 2 years, how order can be issued, my lord. So there's some question, my lord, need to be inquired, my lord. That is my meeting, my lord, of meeting was on, my lord, 22, my lord, October, my lord. Now, this duty, that was due to some urgency, my lord, due to the bond call, my lord. Was supposed to.
What is the total amount? What is the total amount?
Total amount, my lord. Total amount is exactly not mentioned, my lord, in the prayer also, my lord. If my lord may kindly have a look at page number 13, my lord, and number 1, my lord. This is the minute of meeting, my lord, by the administration and my lord.
This one?
1-3, my lord.
IA. Oh, sorry, writ petition.
Writ petition, my lord. The coordination consultative meeting to discuss and resolve the issue pertaining to indefinite bond call by the Joint Action Committees, DRS against the hydropower and power departments convey on. This is convey, my lord. Now, decision, my lord, down below C, my lord. After the trade bear discussion between the Joint Committee and Department, the following resolution adopt for the greater interest of the general mass in general and the Dari circle in particular. The Joint Action Committee called the indefinite bond call with immediate effect. Damage, transformer, and hydro power department is to put for maintenance immediately. A new transformer has to be procured and direct connection to be given from 14-15 kV to 11 kV without depending on the transformer line of the power. This now at 6, my lord, we'll see, my lord, that was 6 months. The Department of Power has issued to wait 2 months. And it seemed, or 4, my lord, within 45 days, my lord, this has to be done, my lord. Now, my work order is 2024, my lord. How, my lord, emergency, my lord, after less of more than 2 years, how did the order? So we need to some inquiry, my lord, whether this competent authority with the approval was taken or competent authority. And the work order is of 2022, my lord.
What is the amount?
amounts 13 lakh 450
From where you again?
from work order.
2 work orders, 3.
3 work order.
Heard, Mr. Will dispose it of. Learn counsel for the petitioner. And also heard Mr. L. Learned standing counsel. Power Department. For all the respondents.
My lord. Sorry, my lord, not for 1, my lord. From 2 to 7, my lord.
2 to 7.
Oh,
Who else? You are one.
No, my lord.
I'm for 1 and 3.
Sorry, my lord.
1 in 3.
Mm.
You right first, then MSP Pangulan State Council respondent number 1 and 2. 1 and 3.
Yes.
Then rest Mr. L permit Standing Council for Power Department for respondent number 2, 4, 5, 6, 7, and 8. 5, 6, and 7. Sorry. Petitioners, huh? There are 2 petitioners. By filing this next para, by filing this writ petition, the petitioners have prayed for a direction to the respondent authorities to release the payment of outstanding bill amount of rupees
13 lakh.
13 lakhs. Only 13 lakhs.
Yes, 13 lakhs.
13
Total.
lakhs, 10,000, my lord. If his legal notice at page number 21, my lord, say 13 lakhs, 10,000, my lord.
You don't know what is your the amount you are claiming.
Sorry, my lord.
Huh?
13 lakh, 10,000, my lord.
Where it is? Where it is?
From page number 21. Therefore, the understanding I on behalf of my client.
13 lakhs, 10,000. For the works executed by work orders number work order dated 23/02/2024, and 26/02/2024. Next para. The petitioners. The petitioner is a you are what? Proprietorship.
Yes, my lord. Limit entry.
Petition number 1 is a proprietorship farm, and the petition number 2 is a proprietor of petition number 1. Please stop. Pursuant to the decision taken by the respondent authorities, the authorities, the petitioners were issued the following work orders. Page 14, huh? You quote this, huh? Page 14, 14, 15, 16. Up to 18, 15 to 14 to 18. Please stop. It is the contention of the petitioners that pursuant to the work orders issued pursuant to work order issued to the petitioners, the firm has duly executed the works for an amount of rupees 13,10,000 in total. Thereafter, a bill was submitted to the responding authorities. However, same is not been paid as on date. Therefore, the petitioners submit that the responding authorities may be directed to pay the release the approximate amount of rupees so and so 13,10,000. Next para. Mr. L. Learned Counsel per the Learned Standing Counsel for Power Department, while placing the instruction, submits that although although the amount claimed by the petitioner is in fact not disputed, the issuance of work order itself raised doubts, as the decision for execution of the works in question was in the year 2022. 22. However, and the work orders appears to have been issued to the petitioners in the year 2024, after the lapse of 2 years. Whereas the decision was to be, the decision to execute the work was within 45 days. Within 45 days.
My lord, 45 days, my lord.
45 days. Christoph, in view of, in such view of the matter, the responding authorities have decided to make an inquiry into the matter. Next para. Having considered that the claim of the petitioner for execution of the work amounting to rupees, the execution of the work for an amount of rupees 13,10,000, with work orders number so and so, dated so and so, and the claim of the petitioner is not disputed by the responding authorities, except raising any doubts as regards the issuance of the work orders, I deem it appropriate to dispose of this writ petition with a direction to the responding authorities to make an inquiry, make an inquiry and verify the claim of the petitioner, and if found admitted, the petitioner be paid the claim amount of rupees 13 lakhs so and so, 13,10,000. It is ordered accordingly. The exercise as directed herein shall be carried out within a period of 3 months from today. 3 months from today. The stands closed. Disposed of in terms above.
Item number 6.
The matter is pertaining to departmental proceeding lawsuit. He was terminated lawsuit. Here lawsuit records should be required lawsuit. I have asked for the records. So it may be listed after 2 weeks lawsuit.
Mr. Bijam, Learned Counsel for the petitioner, on the prayer of Mr. Estapin, Senior Government Advocate for the respondent. Let this matter be listed after 2 weeks.
After 2 weeks.
So as to enable him to produce the records.
Lost. All right.
Lots of
Seven
item
also.
item also.
Same order. 7.
Deeply over.
Item number 8.
What is this? Item 8.
Yes, Your Worship. Item 8.
I'm for the respondent number 16.
16.
Yes.
I'm appealing for respondent number 17 to 26.
Lordship, pro BC.
Am I audible?
I appear for the petitioners in this case.
Yes. What is to be done today?
Because today there is a short issue. Short issue is that we have prayed for some interim directions for which your lordships has also passed an order. So no harm will be caused to any party if our prayer in the interim, which is only to the effect that action should be taken. Interim report. I'll just read the interim prayer. In interim, direct that respondent number 124, 125 to dispose of the representation.
Which
dated
order?
29/5/2025. Lots. No, I am reading my interim prayer once again.
Huh. Why you are
Which is
interim
at
prayer?
page 40, your lordships.
Pleadings are
My lords,
complete.
Yes, yes. Pleadings are complete now.
Pleadings
It
are
can be hard.
Yes.
My lord, am I audible, my lord?
Yes.
I am for respondent.
This
Yes.
It will be difficult.
Difficulty.
Yes.
but since
My lord, am I audible? I'm Mr.
Yes,
T.
yes.
Martin.
You are audible, but not visible.
Yes. My
that's the
video is
condition
not
with me
changing
also,
on.
Lords. I am trying to start the video. It is not getting started.
You are also not visible.
Yeah, I know.
You
I'm
are
trying
missing.
again and again to start my video, but
We all are
I'm-
missing your faces.
My lord, what I
but at
pray,
least my
my lord,
lords is visible clear.
since pleadings are complete, let it be fixed either for admission hearing or whatever, my lord.
He's praying for some interim order.
Interim order at this stage, my
We
lord.
have raised the question of
Pleadings are complete
maintainability,
now.
and on that 24-26, your lordship was pleased to pass an order that the question of maintainability shall be considered. So now, since we have these technical issues, may I pray that this may be taken up day after tomorrow. We will present physically.
Lords, can I just take my lords to the order of 28th of January? And then I'll just read my interim prayer. I don't know
Yes,
why
your-
state
No, your
should
prayer-
oppose my interim prayer.
No, state is not opposing.
Then, my
Private
lords,
parties are opposing.
private parties will, if they are clean, they will suffer no harm. And we are only saying follow the Supreme Court's mandate. We are not asking for anything else. And that is the law of the land. And what is happening, your lordships, is it is clear-cut violation. There is a famous judgment, my lords, of Priya Gupta, which says once the law has been settled by, laid down by the Honorable Apex Court, every other court and authority is bound to follow it. If they don't follow it, that is contempt in itself. All we are asking is they should at least go through our representation and pass an order. Meanwhile, we can come and argue in physical also. But what is the harm which will be caused to anyone in such an innocuous, unless they are hiding something, which is visible from the affidavit of 20 respondent number 27 also, that he has forged the document.
Mr. Pracha, we'll
My
fix
lords.
some other day. And that as regards the maintainability, This will be, this is already been recorded by an order dated 03/03/2026.
My
We'll
lords,
consider everything.
My lords,
We'll consider
maintainability in
everything.
its present form and style only.
Ah.
So there is not the intrinsic aspect of the maintainability,
See, Mr.
My lord, sir.
One of your colleague, Mr. Pertin, has expressed his difficulty through the virtual because of the technical problem.
All right,
and he's very
Milods,
he's
all right,
serious
Milods,
about the
then
maintainability.
Milods,
You agree that
then
we'll fix
Milods,
some other-
Milods, if my learned friend is in difficulty, I would not be able to oppose that.
Heard Mr.
Otherwise, there is some
M.
urgency in this matter.
M.
But
Pracha,
due to
counsel for the petitioner. Petitioners or petitioners? Huh?
Milods may
Also
keep
heard
it then in
Mr.
second week.
Who is one,
Second
two?
week.
Lordship, I am for 1, 3.
S. Tapin, London Senior Government Advocate for the
1, 3,
state respondents. Then
My lord, I am for respondent number 7 to 11.
7 to 11, T. Pertin, huh? And Mr. Sekia.
Well, I am for the
Sekia.
respondent number 17 to 26.
Mr. And then you are 16. Deepang, Senior Counsel, assisted by MS Artaka for respondent number 16. Mr. PJ Sekia, Senior Counsel, assisted by, who is assisting you?
P. Bodlo, Your Lordship.
P. Bodlo for respondent number 17 to 26.
26.
26, huh? Then 28. The Jamo.
Milods, can I request for any date from 3rd
SK
to
Jamo,
5th?
huh? SK Learned Council for 26, 27, for respondent 8, yes.
Milods, can I request for any date? Then I'll also try to come physically from 3rd to 5th if your lordships is it is convenient to my lords and my learned friends also.
My lord, 3rd to 5th will be difficult for me.
In fact, we're encouraging the virtual mode, hearing through virtual mode. But due to technical problem.
All right, my lords. All right.
Anyway,
All right, my lords.
You
28th then.
Agree on that?
28th.
28 is not possible. It's holiday. 28 is holiday.
No, my lords, which date my
28
lord
is
just
a holiday here.
pronounced? No, my lords, I am just asking the date which my lord has pronounced just now.
No, 28 is a holiday here.
No, I could hear the date, my lords. I am asking the date. If your lordship can kindly repeat the date or someone.
That's why I'm saying you agree on the date.
29th, my lord, I suggest if possible.
No, 28th and 29th, I have some difficulty. 28th is a holiday, 29th.
After 2 weeks, just agree on that.
Yes.
Just give the one after
12.
After 2 weeks,
if convenient to my lords.
Can it be on 11 June then, my lord? 11
list
June.
the matters after 2 weeks on
8th,
11.
my lords, I request for 8th,
11th.
not 11th. 11th, I am busy. Any other date? 8th, if possible.
Or 12,
My
my
lord,
lord, I am praying for
8,
12.
there will be some difficulty because 10th or 11th.
12, my lord, can it be, my lord, on 12th? That's
Yes,
the
12 can be.
virtual day as well, my lord. Monday and Friday are the virtual. So 12 can be, my lord, virtual.
12th.
12.
All right,
12th of
lords.
June.
All right,
Obliged, my lords.
Obliged.
Item number 9 and 10.
What is this IH for?
I is for the stay of the further process of the examination.
Huh?
Further process of the recruitment.
Result.
For stay of the further process of the recruitment process.
That is already over.
Not yet over because although the exams are over, but the appointment letters are yet to be given.
Result has been declared.
Result declared.
This is for
The
not to declare the result.
No, for further process of the recruitment.
What further process?
For-
Once the result is declared,
Result is declared, Your Honor.
Public Service Commission. It's a Public Service Commission.
Yes.
Who is for the result has already been declared.
Result declared.
Recommended.
Already.
Recommended.
But in respect of there's
have,
one.
Yes, please.
Yes. But my IA is regarding the stay of the further process of the recruitment, Your Lordship.
Further proceeding.
Now, yes, although the results have been declared, but one result is still pending, which they have stayed due to this petition. And my
To stay the result declaration. 280120 already declared. How can we stop?
or your worship, or to state the further process of the examination dated so and so. That is my second prayer. Now, since the result has been declared.
Declared how? What remains?
Yes, right.
What remains?
The appointment, your lordship. The appointment. Because the appointment is yet to be given. So I'm praying that the further process of the recruitment, your lordship. That may be state for some.
The selected candidates before us?
Your lordship.
Selected candidates are recommended candidates are before us.
No.
No, then.
No.
Because
your lordship, in this case, they are yet to file.
Has created third-party rights.
They are yet to file any their affidavits. The state.
Let them file.
Despite being given the clear specific direction.
We'll dispose of this.
Your Lordship, IA is not maintainable, Your Lordship. IA can be dismissed, Your Lordship, because we have raised our objections also in the IA, saying that that interim.
Now, Your Lordship, regarding the maintenance of the IA, that has been heard and discussed. And as per the last order, it is said that the IA still survives. Because in my prayer, it also contains that the further process of the examination should.
Where is the order that it is maintainable? By which order?
I'll this order dated order dated 0303, Your Lordship. That page 4, second paragraph. Second paragraph, Your Lordship. It appears that by an order dated 18/2/26, 10 days time was granted to all the respondents, which has already been elapsed. However, it appears that in the meanwhile, the result of the written examination, which was sought to be stated in the conducted IA, has been declared. However, the alternative prayer for holding the recruitment process was also made in the interlocutory application. Thereby, the interlocutory application still survives. This paragraph, Your Lordship.
However, considering the facts and circumstances, this case, the court is not inclined.
Therefore,
before filing a yes.
Now the state, despite being, if Your Lordship look at the order dated 13/02/2026, Your Lordship has given specific direction to the respondent, that is the state, to file reply within 10 days.
Well, the result declared nothing will go on merit. We'll decide the writ petition.
Lordship.
Then the state has not yet filed the reply, Your Lordship.
Yes,
my
lord will be. You are challenging the process.
Yes, the
on
recruitment
what
process.
ground?
On the ground that there is illegal reservation.
Illegal reservation.
Yes, in respect of the PWDs, persons with disabilities. Now, the reason that I'm citing before Your Lordship is that, Your Lordship, if we look at the advertisement, Your Lordship.
So reservation is on by the state only.
Yes, my lord.
Not the Public Service Commission.
My lord.
Who decides this thing?
Public
you have
Service
the policy.
Public Service Commission. They have declared the result, but they have not declared it for one category, blindness. That category they have not.
So his claim is on that.
Yes.
As regards the blindness.
Yes.
No. I belong to the person with locomotor disability.
Yes, the reservation made for the.
So according to you, this post should have been reserved for not for this
No
thing.
reason.
Your Lordship, kindly look at.
It should be for the locomotor.
No, Your Lordship. Your Lordship, kindly look at page 24 of my petition. There, Your Lordship will get things very clear. Page 29, Your Lordship. 29 is the advertisement.
Had Mr. K. Taja, Land Council the petitioner. You file affidavit.
But in fact, despite various communications, and PWD and PHE, they are not filing the affidavit. We will go by the affidavit filed by the Department of Sajeta. who will be the implementing agency, who is the implementing department for these disabilities.
Sajata wish for that. What is your justification?
Justification, my lord, in fact, of course, some exercise should have been done by the departments in identifying and reserving the quota for these disabilities, because there are now, after the 2016 amendment, the number of disability categories have increased, and accordingly the quota by way of a roster, it should have been identified, and the category of disability also has to be identified. Of course, there is
That has
issue.
not been done.
I've seen the affidavit. Most probably, the departments have not been done.
You also file an affidavit if you have that view.
Yes.
If it's your opinion, if it's the stand, you file an affidavit.
Yes.
Yes. What do you say? Have you carried out certain exercises?
No.
You have not. Then how can you do that?
No, Department of Sajata has written to the other departments to make a roster for identifying this post. The department,
including your department.
Yes.
Then now ball is in your court now.
Yes, and
yes, RWD also, power also. What is your stand? Have you filed the affidavit?
Yes. RWD stand. They admitted in our button, they have not indicated the port. Now they do answer. In our way, indicated. Yeah. Later also.
Affidavit, you cannot.
Yes, my lord, I'll have a discussion with.
I heard Mr. K. Tajalan counsel for the petition.
Yeah.
At this stage, you will not consider the IA.
Yes, Your Lordship.
Yes,
We'll dispose of the IA.
You also, on my place, both the matters may be heard on third together. On third of
It's not possible. At least 2 weeks. We'll make a last chance. It's regarding selection process.
APCS has not declared the result with regard to this disability quota.
Disability has not been declared, Your Lordship. Only regarding J Civil we have declared. Disability.
Already.
Lordship, disability we have kept in the sealed cover. That has not been declared, the result.
It has not been declared.
Yes.
Yes, that is one is still pending, Your Lordship. One result is still pending to be declared.
So there is no
You are
requirement of
concerned
any
about that
interim
only,
order.
not to the other regular, the general categories.
No, Your Lordship. I'm concerned about other category also. because-
Also?
Yes.
Okay.
Because
We'll just keep it and then. K. Tajalan counsel for the petitioners. Next para. Mr.
In fact, the petitioners, they have not qualified.
G. Tarak learned standing as RWD, as well as Mr. Tigadi learned counsel for standing counsel, Sajeta. Respondent number? No. You find out, Sajeta. 7 and yours?
4.
4 and 7. 7 and 4. Have submitted that an affidavit in opposition have already been filed. On the prayer of Mr. Enraton, Learned Additional Advocate General, and Mr. L. Perme, Learned Standing as a power department. Further 2 weeks' time is granted to file. You have also filed. You have already filed.
Yes.
Then 3 of them have
Lordship.
filed their affidavit.
Lordship, for
Okay,
respondent
three.
number
Yes.
respondent number 2 and 3 also, I have already filed my affidavit, Your Lordship.
Then 4 of them have filed their respective affidavit in opposition. Affidavits in opposition. Next, better. Then you write, Mr. On the prayer, Mr. Enraton, Learned Additional Advocate for the state. Further 2 weeks' time is granted to file counter affidavit on behalf of
Malota,
respondent
1,
number
5, 6, and 8.
5, 6, and 8. As a last chance.
Yes, Malota.
List the matter after 2 weeks.
Obliged.
Obliged, no?
Item number 11.
May please, my lord. In this matter,
Incompetent to transfer.
yes, my lord.
Authority not competent.
Not competent.
Then
Secondly, malapidi, my lord. With the punitive
writ petition allowed.
My lord, I need to file affidavit.
What affidavit? You don't have the power to transfer the junior engineer.
No, my lord.
What?
UDC.
UDC.
I'm informed, my lord, within subdivision.
You have.
My lord, I am trying to.
You are the authority.
Yes, my lord.
Competent authority to transfer.
Within the subdivision, my lord.
Ah.
Within the
Then-
subdivision, my lord.
But
From where you are saying that he's not.
but
Who is your appointing authority?
appointing authority is superintendent of engineer. My
Or
appointment.
UDC also?
Yes, my lord.
Okay.
So my appointment order is annexed here, my lord.
Transferring authority?
Yes, my lord. From one district to.
Mr. and the learned counsel for the petitioner. Mr. On the prayer, Mr. L. Permit, learned standing counsel, power department, further 2 weeks time. 3 weeks.
2 weeks.
4 weeks.
2 weeks. 2 weeks.
3 weeks time is granted to file affidavit in opposition. Interim order passed, earlier shall continue.
Most complaint.
Otherwise, I thought I'll dispose of the matter.
Item number 14.
Yes, sir. Anything? What is to be? Why it is listed for today? Listed today.
It was for this
Yes.
reply, my lord. Affidavit in opposition. Government is yet to file the affidavit in opposition, my lord.
Yes. What is the matter?
May I, Lordship? They have, Your Lordship, the petitioner, Your Lordship may give direction to the petitioner to serve extra copy, Your Lordship.
No direction is required. You serve extra copies.
My lord, my lord. Yes.
All right, Your Lordship.
You are for?
Also await. I am for respondent number 9, but
9.
up to 54, respondent 54, that respondent number 8 to 50, service is still available.
Okay.
I am for, otherwise I am for 9.
Who is, when the affidavit was, when the steps were taken? 12/8/2025. You take press step
My lord.
in respect of remaining response.
Yes, yes, my lord.
Heard Mr. T. Demotion, counsel for the petitioner, and also heard MST P. Pang, learned state counsel for state respondents. Number
1 to 3, Your Lordship.
1 to 3, and Mr. D. Soki, learned counsel for respondent number 9. Who is respondent number 9? Private person, private
respondent.
Private respondent. Okay. Next para. It is seen that no, please stop. It is seen that the steps for respondents were taken on 12/08/2025. Just how about no, the service reports are still awaited in respect of respondent 8, 10 to 90, 21, 22, 23, 25 to 29, 31, 33, 35, 36, 38 to 50, and 52 to 54. Mr. In view of Mr. Jamu, learned counsel for petitioner, is granted a week's time to take fresh steps
My lord.
for the unserved, for the above referred respondents who have not been, whose service reports are still awaited. Next para. The MS P. Pang, learned state counsel, and Mr. D. Soki are granted 3 weeks time to file affidavit, file the respective counter affidavits. This after 4 weeks.
Okay, okay, my lord.
Obliged, Your Lordship. Extra copy.
Item number 15.
Okay.
Ever service report.
Here, Lordship, step was taken to private respondent number 3
When?
on 4/12/2025.
So, you want to take press step?
No, already we have taken.
No, then it's up to you whether you want to take press steps. It's been 4 months, or we'll wait for some time.
We can wait for some time.
Mr. D. Baji learned counsel for the petition, and also MSP Pang learned counsel for the state counsel for the state respondents. You have filed affidavit.
Yes, sir. We have already filed your lordship for respondent number 2.
Who submits that the respondent the affidavit has already been filed. Next para, office note dated 22/05/2026 indicates that the adequate note answer notice has been received in respect of respondent number 3. In BMO, let this matter be listed after 3 weeks awaiting service reports.
Lordship, there is an interim order.
Interim order passed, I'll just continue.
Obliged, your lordship.
Obliged.
Item number 16.
Non appears for the petition on call.
Your Lordship, I'm for petitioner.
Yes, Mr.
M. Kamcham.
M. Kamcham, Land Council by petitioner is present. Mr. MSK, and no, you have filed the affidavit.
No, my lord.
You want
We need
some
some
time?
more time.
On the prayer, MSK Wang Learned State Council further 3 weeks time is granted to file affidavit in opposition. Next para. The service, service in respect of service of notice has in respect of respondent number is duly affected. Question does service is complete. List for admission hearing after 2-3 weeks.
Obliged.
Item number 22-23.
Where is 17? Item 17.
Okay, yes. Item number 17.
Yes.
My lord, considering the urgency in the matter, on 11/12/2025, we were allowed to take Dusty. We were taken also, but somehow the acknowledgement of receipt have been misplaced in the chamber. I pray that we may be allowed to take Dusty service again upon respondent 8 to 10.
Okay. Mr. Deepangi Lan Senior Counsel submits that although the service was effected by Dusty mode, the acknowledgement has been misplaced. Therefore, prays for some time to take fresh steps by Dusty mode again. Next para. Prays allowed the petitioners to take steps for service of fresh to take fresh steps for service of notice. Upon respondent number 11.
8 to 10.
8 to 10. 11 also. 8 to 11.
11 also I will do.
11. 8 to 11. Huh? 8, 9, 10, and 11. Huh? By Dusty mode. Thereafter. On
So far as 11 is
effective-
concerned, I'm appearing.
Okay. Then 8, 9, 10. Then by Dusty mode. Huh? Then to file affidavit as regards the proof of service upon above respondent. The Endangered Land Council, but respondent number 11 is present. What is the issue?
This is regarding appointment of additional public prosecutors.
Okay.
There's no discussion with the district and session judge as contemplated under the CRPC. That was not done.
Regular appointment. No.
Not regular appointment.
Okay. When do we?
Let it be after a week. We'll do it by tomorrow.
List the matter after 1 week.
Item number 20 to 23.
May it please your lordship, my lord, in the pending writ petitions, 2 IAs have been filed. One is 108.
Would like to file objection?
Correct, well filed.
And my lord, that they were filed, but I just want to highlight one aspect before your lordship.
It's okay. Let them. We'll have to give them.
But one thing.
We'll consider. Let them. We'll have to give them opportunity.
We have, in
But
fact,
if
it
they
is,
don't want to file, if they argue the matter, it's okay.
lordship, there are certain allegations that we have to rebut that.
No, there are 2 IAs. So one is IA number 108.
This is listed for the first time.
For the first
So
time.
we'll issue notice, although they are appearing. So we'll fix.
Otherwise, the all petitions are fixed on 2nd of June.
We'll fix on that day. On that day.
In the meantime, I'll be filing.
By that time, my lord, then a reply should come.
Heard Mr. S. Datta, Learned Senior Counsel, assisted by
H. Nath.
H. Not Learned Counsel for the applicant. Do you write?
But my lord, may I just submit one sentence, my lord?
Same order.
My
In
lord,
all the IAs.
In all the IAs, my lord, 2 different orders.
Okay.
My lord, as far as 108 concerned, my lord, may I just make one submission?
No. Today it's listed for first time. We'll issue notice and they will grant them. We'll direct them to file the objection, if any, or not before the next date. We'll fix the matter on 22nd.
No, it is fixed on 2nd of June.
2nd of June, yes.
One IA date we have filed, lordship,
is an
that is fixed on 2nd.
Praying for alteration of modification of vacation of order dated 26/06/2026 passed in WPC 118/2026. Next para issue notice returnable by 2nd of June, 2nd of June. As all are represented, respondents.
All are represented, possibly, because
First time for respondent number 4 is 62. BCCI.
62.
On WPC 63 in 118, I am for respondent number 9.
118.
Yes.
What I'm asking is all the respondents are represented. Then you write all of them as the enters appearance and accepts notice on behalf of all the respondents. No formal notice need be served. However, extra copies be furnished to the Learned Counsel for the respondents. Then the respondents may file their objection, if any, or not before the next date of listing. Then list on 2nd June. Then IA 110, sorry.
110.
Is what?
110 is also against an interim order that is in respect of WPC 97 of 2026.
1203, 2026. Order is 120320 in WPC 97 of 2026. Same order. Here also all are represented.
All are.
Same order.
The only difficulty is that, my lord, they have filed a contempt, my lord. And because of this stay order, my lord, everything has come to a standstill.
Just after 1 week.
So, if your lordship kindly makes an observation that it will be taken up for final consideration.
Unless we consider it, sir. We'll see.
Contempt is different aspect, lordship. There was a stay order, lordship. In spite of that, they were functioning, lordship. Obliged.
Item number 24 to 26.
IA for what?
My lord, the IA for Impleadment, my lord, I'm one of the participants in the tender process, my lord. Now, which is now that the process has been stayed, my lord.
Objection? No. Okay. And Mr. T. Tagum, Learned Counsel for the applicant, and also Mr. MS No, Mr. H. Lampu, learn counsel for respondent. You are the only respondent, right?
No, my lord.
Respondent number 1 and MSP T. Wang learn state counsel for respondent number 2, 3, 4, and 5. Opposite party respondents. Huh? You're just right. This is an application. Bring for impleadment of the applicant as respondent, as party respondent in connected WPC 130 of 20, not connected, WPC 130 of 2026.
As the respondent number 5, my lord.
As respondent number 5.
6. Okay, 6, my lord. So sorry.
You have said
No.
5.
6. You know, it is 5.
Yes, 5.
This is 5.
Respondent number 5. Huh? Next. Next para. The petitioner. Then opposite party. Next para. The writ petition. Opposite party. As well, the connected WPC being 1 to insurance. 130 of 2026, challenging the tender process initiated by the executive engineer, Maming PBW division, East Coming district. Pursuant to the invitation for bid within bracket IAB, dated 20/06/2026, in connection with the project, namely integrated development of various administrative infrastructure at newly created Sijingwa CO headquarters, East Coming district, Arunachal Pradesh. We take it from Peratu. Type 2 quarters, so and community will having an estimated cost of 2970 lakhs. Next para, it is submitted by Mr. T. Thagum for the applicant that the applicant has also participated in the tender process. Did they stay?
Yes, stay.
And in the aforesaid tender process, who is a necessary party in the connected repression, therefore press for impleadment of the applicant in the said in the aforesaid writ petition. Next para. Having considered that the tender process initiated by the respondent authorities pursuant to the invitation for bid dated 20/06/2026, wherein the petitioner, the applicant, has stated to have participated in the said tender process. I'm of the considered view that the applicant is a necessary party for necessary in the connected writ petition being 130 of 2026. Accordingly, this application, accordingly, the petitioner, the applicant is required to be impleaded in the present in the connected writ petition. Accordingly, the applicant is allowed to be impleaded as respondent number 5 in the connected WPC 130 of 2026. The application, next para, application, IA stands allowed in disposal.
Deeply obliged.
Next para, in writ petition, in view of the order passed in IA so and so. You'll file the.
My lord,
We'll file it.
my lord, in the meantime, my lord,
The council for the newly included respondent number 5 is directed to file amended course title. Huh?
Madam,
It is required.
Madam, it's not required. They will correct it, madam. Registry
No,
can correct.
problem is correcting is something different. Nowadays, the CIS doesn't support that.
My lord, in that case, it is to be done by the writ petitioner, my lord. Because in their case only we.
What is there? It's a one page. You file it.
It's okay, ma'am.
Only it doesn't make any difference. Then petitioner, learned counsel petition to file amended course title. List of on receipt of the amended course title registry to incorporate the newly respond number 5. List of nothing. You have all the papers.
My lord.
And affidavit.
Yes, my lord, we have filed for respondent 4, my lord.
You want to file?
My lord, in the newly impleaded, my lord, I'll discuss with required. My lord.
After 2 weeks.
My lord, it's already listed. I believe, my lord, fixed on 3rd June.
As the matter is let the matter be fixed on list on 3rd already there.
June. It's already there, man.
3rd of June.
Yes, ma'am.
Okay.
Deeply applied.
Item number 27.
Yes.
My lord, I am representing respondent number 2. Yes, I have entered this file my wakalan number 2 date.
Yes.
My lordship, on last date, we were asked to get some instruction regarding the service of notice upon the petitioner. And we have the instruction, my lordship.
Of the petitioner?
Yes, my lordship. He alleges that he was not served with the hearing impugn order, my lordship. Notice of hearing. It was issued on 16th, my lordship, 16th March 2026.
It was affected.
My lord. Affected. My lord, I couldn't get the word.
Whether I'm asking whether this notice was effected. Whether it was served duly.
Yes, my lordship. In page, second page, there's 424, my lordship. It was dispatched, my lord.
This, my lord, the acknowledgement, if there is no, the dispatch, there is a dispatch or that is different. But
ADC Sagali Tabaya Yaha. Notice of hearing.
it was acknowledged by the petitioner, that is the important.
It was served.
No, it was acknowledged by the petitioner or not. That is that this has never reached to the petitioner. If any records of acknowledgement, no, that is important.
The notice was served through additional Deputy Commissioner Sagal.
ADC Sagal.
Dispatch register. This is only this dispatch register.
Dispatch is not sufficient. Acknowledgement is required.
You have not received?
Yes, my lord. I have not received.
Who is for respondent number 2?
Yes,
You are?
I'm Murang Logi.
President BJP Papumpare.
Yes.
So the issue is that you have not been served with copy.
Yes, my lord. That is the
main issues. I've been not served notice and without in my absence, the order hasn't passed in ex parte. That is the issue.
You bring on record whether this has been served or not. If you have served, nothing remains.
Yes.
If you have not served, you'll have to redo the things again.
Yes, my lord. That is the exact.
Third, Mr. Nibo, M. Nibo, Learned Counsel for the petitioner. Next para, Mr. MSK Wang, Learned Counsel for the Learned State Council, by placing the copy of the notice for hearing dated 13/03/2026 and the dispute register submitted. The petitioner was issued notice which was duly served to the petitioner, which the Mr. M. Nibo, Learned Counsel, disputed, and to which the Learned Counsel, Mr. Nibo, has disputed the disputed said submission. Next, considering about Mr. MS K. Wang, Learned State Council, to bring on record indicating as to whether the notice dated 13/03/2022 was duly served or not. This the matter after 3 weeks.
2 weeks, man.
2 weeks. Mr.
Tiloma.
Tiloma, Learned Counsel for the respondent number 2 is present.
Obliged, most obliged.
Item number 30.
I'm sorry, my lord. Item number 24, my lord.
Interim order.
Item number 24, my lord.
24.
Yes, in connected with petition, my lord, there is a state order, my lord. That may be, sir, that may be extended, my lord.
Item number 24.
In the collected writ petition, writ WPC 130, my lord, of 2026. Yes.
Interim order passed, let's continue.
Yes. Obliged, my lord.
30. So, sir, I'm told that my senior friend is on leg in court number 5. Also.
That's what is the matter?
This is a pay fixation also. Pay anomalies.
Ready?
Otherwise, we are ready. Also.
Constable driver.
Constable driver also.
I think, can I take it up? Take up this matter. Just find out. You come back after 5 minutes.
Your Lordship, matter will pass over for the time being.
Time being. I vaguely remember, I think I had some consultation.
On records, so I couldn't find it.
No, some consultation have been made to me when I was that side. You just discuss with your senior. This is a pay enhancement.
Pay. No, pay. Fixation of pay.
Fixation pay. Regarding about this thing.
Driver and civil driver. Police driver and
this is petitioners, driver constables.
Oh, yes, yes.
I think so. You discuss with him. In that case, I mean, I may not be able to take up. After some time.
Item number 31.
May I please your lordship?
Yes.
Lordship, I am for the petitioner.
IAS for what?
My lord, initially there was some interim order. So that IA was for vacation on the interim order.
Okay.
But subsequently, by order dated 16/12/25 that IA was supposed to be treated as affidavit.
Okay. No, not this one. You ready?
Yes, Lordship. Lordship, should I? May I please, Lordship?
Yes.
Lordship, the petitioner at a relevant point of time was serving as a DGM HR by virtue of a special scheme of incentive for the employees who were posted in Arunachal Pradesh and Assam, whereunder promotion to the next higher grade was initiated for the employees posted there in the projects of AP and Assam. The petitioner and other eligible persons came to be promoted to the next higher post of that is AGM HR by the official order dated 15/11/23. Subsequently, thereafter, the petitioner was given a further promotion to the post of GM HR. Being such situated, there was a subsequent change in the corporate policy, that is by the CHRC 950/25 dated 1/7/25, where the earlier scheme module notified dated 1/7/25 stood withdrawn. That was also with effect from 29/5/25. Subsequent thereto, the petitioner was placed in his original post, which is DGM HR, by impugn order dated 11/7/25. This order is a common order in respect of other employees situated like, and hence this with the petitioner. Lordship, the company introduced an incentive policy offering promotion to the next higher grade for joining the project for employees who were willing to undertake assignments in the Northeast, and the number of employees, including the petitioner, volunteered for these projects, relying on his explicit promise of career advancement. Subsequently, the company withdrew the aforementioned policy and introduced a new policy offering only monetary benefits effective from one prospective date. Concurrently, employees who had already been promoted under the old policy and were serving in the Northeast were demoted to their earlier positions with effect from 29/5/2025. Lordship, in that regard, I would just simplify my appointment structure. That is, first I was appointed as DGM HR on 29/9/23. Then I was promoted to AGM HR, that was on 1/11/23. File Annexer 5, that is in page number 30, Lordship. Then I was promoted to GM HR, dated 12/12/23, that is in Annexer 6, page number 32, Lordship. Then again, I was promoted to, I was back to my original post, Lordship. That was on 29/5/25, that is in Annexer 7 of page 33. Then I was back to again DGM. Hence, Lordship, the old policy being withdrawn and the new policy, which is retrospective and silent about the service conditions of earlier employees who were already given benefits under the earlier policy, Lordship. And then the stay upon the impugn order, which gives the petitioner to be intrinsically treated as general manager, since the demotion order was stayed. Hence, Lordship, the demotion is illegally untenable and it contravenes the fundamental legal principles of promissory estoppel, Lordship, and legitimate expectation. The company's initial policy, Lordship, is constituted of a clear and focal, unequivocal promise of promotion of employees acted upon this promise to their detriment. by volunteering for challenging assignments and relocating in the notice areas. Lordship, this reliance created a legitimate expectation of continued employment at a higher grade. But Lordship, then, sudden demotions despite...
Withdrawn on 1/7/2025.
Yes, Lordship.
With effect from?
That is Annexer 4, Lordship.
No. It was withdrawn with page 33.
Yes, Lordship.
1/7/2025.
Yes, Lordship. 1/7/2025, wherein there is a description.
It stands withdrawn with effect from 29/05/2025.
Yes, Lordship.
You are promoted based on the earlier circular?
Yes, I was promoted.
On last promoted when? GM 17/1/2024, page 32.
Yes, then after AGM, I was being promoted to GM 12/12/23, Lordship.
No. GM is what? This is what? Page 32 is what?
Yes, Lordship, page 32. Annexer 6. Office order dated 17/1/24.
With effect on 12/12.
3 of the employees' names were listed therein, wherein the petitioner's names also appear in serial number 2, Lordship, with effect from 12/12/23. May I please again, Lordship?
So this withdrawal is with effect from 29/5/2025.
Yes, Lordship.
Then?
Should I read the guideline, Lordship?
What guideline?
Their guideline, the CHRC 950/25.
Yes.
Dated 1/7/25, wherein there is a description about the scheme for extending benefits to the
Page
employees.
32, you are reading.
No, I'm not reading. I'm telling about the annexer, Lordship.
Page 33.
Yes, Lordship.
Then?
Page 33.
You come to page 33, this earlier circular.
Yes, Lordship, there is, should I?
Under which you were promoted a GM, up to GM, right? That has been withdrawn with effect on 29/05/2026.
Yes, Lordship. The scheme of
board approval.
Yes, to encourage the employees to serve at a remote project.
The appointment order was 17/1/2024. Then how this can be applied?
Yes, Lordship. Their subject is that scheme for extending benefits.
I've seen it. So this page 42, Annexer 8, 11/7/2025. By this order, you have been placed.
Yes, Lordship. My name appeared in a serial number 5.
Reverted back to DGM.
Yes.
With effect on 29/5/2020. Okay. Yes.
Yes, Lordship, then the facts in brief I'm telling about. On 12/10/2023, company issued a circular.
Then I've seen it's okay. Let us know. No time to buffer also.
Okay.
That's history.
That in the present IA filed by the respondent's Lordship, seeking vacation modification of the interim order is wholly misconvinced. They seem to be meritless and liable to be dismissed, Lordship. And the respondents cannot be permitted.
No, what's wrong with this withdrawal of the circular? First, you are challenging the circular, right?
Because it is violative of promissory estoppel, Lordship.
What promissory estoppel? What promissory estoppel? What is promissory estoppel?
Lordship, the present case, I have similarly squarely attracts a doctrine of promissory estoppel that I have a citation of Motilal Padampat versus Sugar Mills Company Limited versus State of Uttar Pradesh.
So therefore, once you have been promoted
Yes, Lordship.
by an applicable circulars, by providing the benefits, subsequently they cannot withdraw.
Yes, Lordship.
And report you or reverted back to the original post, which would invite the, which you once, amounts to?
No, Lordship, it was a promise made by the company to me or other petitioners like me. So,
Are you challenging the withdrawal?
no, Lordship. My prayer
See,
is.
therefore, if you are not challenging the withdrawal, the withdrawal is with effect from 29/5/2026.
Yes, Lordship,
And
I am challenging it on the grounds that my accounts are not at all clear. It is not settled, and they are being handed over to NHBC by now. So there have been instances, company may change their policies at fine point of time, but I cannot be victimized. I become the victim.
What are you now? Are you still working?
Yes, I am still working. I am appointed in Baksar, Bihar.
Now?
BTPP, yes, Lordship.
As DGM?
Yes, Lordship. I'm appointed back to DGM, HR.
What about others? What about others? They are not aggrieved. They are happy.
Might be, Lordship.
There are 10%, including you. Is the original grade label as detailed under? Yes, anything else?
Yes, Lordship, I want to show the citations. In this case, Lordship, Honorable Supreme Court held that
citation?
AIR 1979 SC 621. Motilal Padampat Sugar Mills Company Limited. Versus
1979?
SC 621.
621. Para? Paragraph?
I have highlighted there in Lordship. Where the Honorable Supreme Court held that the state makes a promise and the promisee acts upon it. The state is bound by such promise even in absence of a formal contract.
It's not a promise. You have been granted at the relevant time. You have been provided with the benefits as then was applicable or in vogue. Now they have decided to, by a policy, they have decided to change that policy. Therefore, from the effective date, you have been placed under in your original post, not from earlier days. All right.
Yes, Lordship.
29/5/2025. Are you challenging the withdrawal? No.
Yes, we are challenging.
Why? Don't they have any authority to withdraw the policy and change the policy? Where you have highlighted? Paragraph?
Paragraph first, second, third. Lordship.
Para?
Para 3, Lordship.
Paragraph 3.
I have summarized it, Lordship.
What summarizing? You tell us which paragraph you are relying. Because you have relied the judgment.
Lordship.
Where is the paragraph?
Paragraph 3, it was, Lordship.
Of what? This judgment?
Yes.
The state government, however, went back upon his assurance.
The Supreme Court further held that doctrine of promissory estoppel can be enforced against the government under Article 226 of the Constitution.
Where it is? You read from the judgment. There are 36, 37, 49, 50, 51. Yes. Then.
Yes, Lordship. Also, there is another citation of Nirmal Chandra Bhattacharjee versus Union of India, that is Supreme Court 1990, where it was said about service benefits once granted cannot be withdrawn arbitrarily without due process. The appellants were, Lordship.
Citation.
Lordship, may I show you?
Not that way. You just give the citation.
Supreme Court 1990, Lordship, para 6 and 7.
What does it mean? Supreme Court 1990. What is the citation, madam?
SCC.
SCC, Lordship.
1990. Then, any volume?
1990, SCC 363.
What is the volume?
2.
363.
Yes, Lordship.
Para 6 and?
Para 6 and 7. Yes, Lordship.
Then what is the name of the party?
Nirmal Chandra Bhattacharjee versus Union of India. Where the appellants were, Lordship, class 4 railway employees, and who were promoted to ticket collectors, that is class 3.
On the basis of some circular.
Yes, yes, Lordship.
On the basis of some circular.
Yes, yes, Lordship.
And that was subsequently withdrawn.
Yes, yes,
And
Lordship. Quite similar.
On the basis of.
Yes, Lord, similar to ours.
Of the circular, that applicable circular.
Yes.
Is it so?
And there, the court directed that their promotion to be deemed valid,
And next.
restored.
Next.
And their positions and granted.
It's okay, madam. What are you? Again, any other judgment?
Yes, Lordship.
Then, any other judgment?
Diganto Kumar Deka versus State of Assam, that is Guwahati High Court 2025.
What Guwahati High Court?
WPC number 5937 of 2025, para 25 and 26, Lordship. Interim orders passed by Honorable Guwahati High Court are binding and must be strictly complied with. Diganto Kumar Deka versus
What is the relevancy?
Lordship, here the petitioner was issued a summary show cause notice from GST DRC 01 without a proper signed show cause notice, and no personal hearing was provided before an adverse order was passed. Likewise with me.
That's why I'm asking why. Why?
Nor I did any professional misconduct.
What is the relevancy?
That the court held that the summary cannot be replaced a proper notice under the rule, and the documents lacked proper authentication and mandates a hearing when adverse decision was contemplated. Lordship, likewise me, no, I was not earlier, I was not said anything about my, nor I did any professional misconduct, nor I was intimated, nothing.
There's no question of misprivilege. They have withdrawn it accordingly on the basis of the new policy you have been placed under your original post. That's all.
It is arbitrary, Lordship, because the respondent company, and they are demoting me from the post of AGM to DGM. And I was granted promotion pursuant to the circular of 12/10.
I understood, madam. Why are you going back again and again? Your case is very simple. At the relevant point of time, there was a circular.
Yes.
Granting you some benefits,
yes,
incentive.
Yes.
Those employees were working in the Northeast, including Arunachal Pradesh.
Yes, Lordship.
On that basis, you being a deputy general manager,
Yes,
you
Lordship.
promoted to AGM, then GM.
Yes, Lordship.
Then when you were working, this new circular
came up
and said that this earlier circular is withdrawn with
Yes.
effect from 29/5/2025. Accordingly, on the basis of new circular, your promotion to the GVM, you have been placed under in your substantive post of DGM, is not it?
Yes, Lordship.
That's all.
But it was a promise to me, Lordship, that relying upon
Promise, not promise at all. It was acted upon.
I was
It's not a question of promise. You have been already granted the benefits. What we'll have to see is whether they have the authority to have this policy subsequently, which caused prejudice or detrimental to you, so far as your promotion is concerned. Whether they can do it or not, that's all.
No, even after the interim order was passed, I was arbitrarily
We are hearing it finally today.
being transferred.
Forget about that. That we are not concerned.
I was being transferred to another project.
Was it there any interim order not to transfer you?
No, it was not like that, obviously.
But finally, considering your matter today, forget about the interim order now.
It was like a punitive action. It was like a side effect of that.
Have you challenged that? Have you challenged the interim order?
No.
The subsequent order, transfer
No.
order. Then what you have not challenged yet, don't make any submission, please. You confine your submission what is in your records.
But however, Lordship, on 11/7/25, the respondent company unilaterally demoted me back to DGM post without issuing any notice, without granting any opportunity for me to hear me, or without any allegation of my misconduct.
Thank you. I have heard many times. You have repeated so many times. That's all. Anything else?
I have more citations, Lordship.
No, it's not required. Promissory estoppel, you are relying that I have seen. Then
Yes.
once you are promoted, you cannot be reverted back on the new policy. I don't know. I'll go through it, that judgment. You give that judgment, you find out.
Which one, Lordship?
92 SCC 360.
That judgment, my lord, it's not available, my lord. It's a wrong citation, my lord.
Then
No. Nirmal Chandra Bhattacharya, Lordship.
Nirmal Chandra Bhattacharya.
Yes, it's a landmark Supreme Court of Nirmal Chandra Bhattacharya versus Union of India.
Citation must be wrong, maybe wrong. Citation.
It is there, if you allow, Lordship.
Okay.
My lord, it is in Google. Oh, but otherwise the citation seems to be 1991 supply 2 SCC.
Supply 2. 1990?
91 supply 2. 1991 supply 2.
1991 supply
2.
Volume 2 SCC 360.
Page remains the same.
Anything else?
That's all, Lordship.
Yes.
My lord, here I'm appearing for respondent number 4 to 9, my lord.
4 to 9 are the company.
Yes, they are the main party, my lord.
Company.
Yes, my lord.
Yes. SB, what is this?
SJVN, my lord.
SGVN.
Yes, ma'am.
It's a
PSU. ma'am.
Public sector undertaking.
Yes, ma'am. It's a PSU.
Okay. So rate will maintain.
My lord.
Rate will be maintainable.
Yes, ma'am.
Okay. Yes. Then
My lord, this entire writ petition itself, my lord, to my understanding, my lord, this is misconceived, my lord. Here, my lord, with some incentive that was given to the petitioner and other similarly situated persons during their time of posting at Italian in the Dibang Valley district, that they have constituted to be a regular promotion, which according to us is only an incentive as long as they were posted here, which was subsequently withdrawn also, Now these persons, my lord, they were, if my lord would come to my IA, my lord, these persons, including the petitioners, they were transferred to Italian on 29/9/2023, my lord, at page 24, annexure 2, my lord.
Yes.
Now since
2023.
2023, my lord.
His name is Kuldeep Raj.
Kuldeep Raj, my lord.
Serial number 3.
3, my lord.
Yeah.
Now it has been said in the petition that on the promise made to them, they so transfer, but otherwise on their willingness, my lord. In fact, they were earlier transferred, and subsequently the company felt that since Italian is a hard place in Dibang Valley district, the company thought it appropriate to give them some incentive to boost their morale, etc. So accordingly, this corporate circular at Annexure 3, my lord, 12/10/2023, this was given, this special incentive, my lord. Annexure 3, page 26, my lord, 12/10/2023, my lord.
Yes. Yes.
Yes, ma'am. Now this circular was on 12/10, then next page, my lord, is the scheme of special incentive for employees posted in Arunachal Pradesh and Assam at page 27. Now 1 and 2, serial number 1 and 2, I will forego, my lord.
After the transfer only, this.
After the transfer, yes, this came, yes, ma'am.
Came out. Then?
Yes, ma'am. Page 27, my lord. 1 and 2, that scope, and then my lord may come to serial number 3, my lord. Incentive for posting, my lord. My lord will see, my lord. All along, it is only an incentive, my lord.
The employees will be given special promotion to next higher grade.
A is the small a, my lord. The employees will be given special promotion to next higher grade immediately on assumption of duty in Arunachal projects. B, employee will exercise and avail status, financial powers, benefits, including promotional increment at all levels along with so-and-so and entitlements of the promoted post. C, on assumption of the charge in the next higher grade, vacancy in SJVN will be recalibrated, and in case of vacancy constraint, junior-most employee of that higher grade will be reverted to so-and-so. Well, this is not relevant. Then may C, D, come to D, man. D, Roman 1, man. DPC of such employee will be conducted as per promotion policy with reference to the post grade employee was holding prior to posting in Arunachal Pradesh, and if recommended for promotion, employee will be given from national promotion, my lord. What we are saying is that there is a promotion policy also, my lord, which we have filed as an additional affidavit, my lord. Now this exercise, my lord, this DPC was never conducted, nothing done, my lord. So from here itself, my lord, we are saying that it is only an incentive as long as you are placed here, my lord, at Arunachal Pradesh.
What does it say? Did say what?
My lord?
DPC of such employee will be conducted as per promotion policy with reference to
post-grade employee was holding prior to posting in Arunachal Pradesh, my lord. Here the petitioner was an DGM, my lord. He was on,
and if recommended,
if recommended promotion, employee will be given national promotion, man. So for this regular promotion, which the petitioner is claiming, my lord, there has to be a DPC, then there has to be a recommendation, my lord. Now the incentive that was given, the petitioner is saying that it has crystallized, that he cannot be rewarded back, my lord, to his original post. Whereas our post contention is that no DPC has taken place. Whatever benefits he was giving, he was taking it as an incentive, man. Only as an incentive, man.
But as per the clause D, if the case is recommended, you will be given national promotion.
My lord.
Taking into account this incentive.
My lord.
You know that?
Yes, my lord.
So
DPC has to be there, and then second.
No regular promotion agent today. Agent, when it is considered,
Yes, ma'am.
I mean, on recommendation, he'll be given the national promotion.
My lord, that
The
will
post which was holding.
maybe, my lord. That will depend on the DPC, my lord. Then subsequently, then there are other issues also. Then
On transfer of
national.
employee SNB location to grade pay skill seniority and the pay is replaced back to national grade
pay fixation, seniority, etc. So for everything to happen, my lord, there has to be some DPC, my lord. But my lord may otherwise see the anomaly, my lord. Person will come here, take the special incentive, my lord, work here for 1 year maybe, then go back and be in a higher position, my lord. That is not the scheme that has been envisaged in the promotion policy, my lord. Promotion policy also we have annexed, my lord.
Promotion policy has different thing.
Yes, my lord.
It's just a circular for incentive.
This is an yes.
So long as they are working in the Northeast region.
My lord. Only as an incentive, my lord. So any promotion that has to be, it has to be as per the promotion policy, my lord. There has to be a DPC, my lord. The DPC will take into consideration the everything, my lord, their performance, their appraisal for everything, my lord. Their integrity, my lord knows how the DPC functions, my lord. And only then they will be given the regular promotion, my lord. Now, when this happened, my lord, what happened, my lord? So due to this irregular that incentive scheme, my lord, there was some extra expenditure on the part of the company, my lord. So accordingly, the audit also raised some objection. That is at page 29, saying that the incentive, my lord, it is contrary to the guidelines of the Department of Public Enterprises, DPE. Notification, etc. So we had to take it back, my lord, and the new policy has come into effect, my lord. And there has been subsequent development, my lord. After this, the petitioner has already been transferred, my lord, to Buxar, my lord, and now now the company is in fact winding up also, my lord, because if lawsuit would come to my additional affidavit, there are two additional affidavits, my lord. One is the promotion policy that I have annexed. Another is the order dated 11/11/2025 issued by Ministry of Power, Government of India. My lord is there.
Yeah.
That if my lord will come to page 58, the annexer 1, my lord.
Which affidavit? Which additional affidavit?
Additional affidavit
Page 50?
55 to 58, my lord. There's
55 to. No, this is something.
by this additional affidavit, I brought on record the order dated 11/11/2025 issued by the Ministry of Power, Government of India.
$55 to 58.
58, my lord.
Something different. This is what? Additional affidavit?
The
filed on?
It was filed that
27 October.
Notary was done on my lord 8 December, my lord, that one 25, my lord.
Additional affidavit.
Additional affidavit. There are two additional affidavits, my lord.
16 December.
Not 16 December.
Applicants to bring on record subsequent development. Anshul Kumar Singh. Is it filed on 16 December 2025?
Anshul Kumar, yes, my lord.
58.
58, my lord. This is 11/11/2025. This is a subsequent development that happened after the filing of the writ petition. The Ministry of Power, Government of India, my lord, to the Chairman and Managing Director, NHPC Limited, my lord. Subject reassignment indication of Italian so and so, and it's HEP to NHPC in place of SGVN for further development. So by this, my lord, in fact, the entire project has now been given to the NHPC. Now, along with the incentive, everything, we are leaving Arunachal, my lord. On next additional affidavit that we have filed, my lord, we have brought on record the promotional policy of executives, my lord. This starts at page 59, my lord. And Annexer 1, page 62 is the promotional policy, my lord.
Yes.
My lord. And I will just take your lordship to a few pages, my lord. Page 66, if your lordship may come, my lord.
66.
66, my lord. This is the general principles, my lord.
Yes.
The DPC shall be constituted for promotion of executive to next higher designation from one pay scale to next higher pay scale. So and so, my lord. The disciplinary vigilance clearance, then APR, submission of APR, everything, my lord, it is discussed here, my lord. How it is to be done, my lord. And constitution of DPC is at page 74, my lord. Now, this is how the transfer, sorry, my lord, the promotion has to be affected, my lord. And only then they can come and claim that promotion that was given to the employee that is crystallized, my lord, that cannot be taken back. But here is a case, my lord, where as long as they worked here, my lord, some incentive was given, my lord. And in that incentive also, it is clearly said, my lord, DPC has to be there for such employees. And with regards to the earlier post, their substantive post they were holding, my lord, that will be held.
You have issued this order placing him as deputy GM, DGM, huh? 11/7/2025 before his transfer.
Before his transfer, my lord. After the change in the incentive policy, my lord. After the change.
On being transferred, if an employee is transferred from here or Northeast, he will be reverted back to DGM.
No, my lord.
So long as they are here.
My lord.
So this order of page 42, writ petition.
42.
Impleadment order was passed in 11/7.
11/7, yes, my lord.
Before he was transferred.
Because my lord.
He was working here only.
My lord. But that is because the policy was changed, my lord. Policy that was recalled on 1/7/25, my lord. That I have annexed in my IA also, my lord. And otherwise in the writ petition.
11/17.
17, it is page 33 in the writ petition, my lord.
Yes, 17.
Yes, my lord. Page 33, my lord. Now that incentive, my lord, the policy which was there, giving them some incentive and placing them in the higher position, place, my lord, that was recalled by this 1/7/2025. And now since that policy was recalled, my lord, that incentive policy, my lord, that is nothing, my lord. That is only an incentive policy, no act, no rule, my lord,
This is not a promotion policy.
Yes, my lord. Since that was withdrawn, my lord, automatically, my lord, these persons who were working on the higher post, my lord, they had to come back, my lord. And no other persons, my lord. This by 11/7/2025, my lord. All those employees, they were brought back, my lord, to their substantive post. No one is aggrieved other than this person who is misplaced.
That's what I'm saying.
My
I
lord.
have to ask her whether others are not aggrieved. Of
My
course,
lord.
we cannot compel them.
Of course, my lord. So this is because of the change in the policy, my lord. That earlier incentive policy, that was recalled, my lord. And that policy had to be recalled because of the objection by the Department of Public Enterprises, man, and the audit, man. Because since we are giving them some incentive, there is some extra expenditure, irregular expenditure. So we recall that incentive, man, by this order of corporate circular of 1/7/2025. And accordingly, since that earlier incentive was policy was.
You have not sought for any recovery,
No,
whatever I mean, consequential benefits when the incentive was provided.
No, my lord, no.
Okay. Only from the date of recalling, withdrawing.
Yes, ma'am.
Do you have
Since
to
the policy
place
was
them
withdrawn, ma'am,
back to
yes,
your
ma'am.
state?
We are not asking them for any recovery, etc., ma'am. That is only thing, ma'am. Now they are saying that this is a regular promotion. It has crystallized, ma'am. So I should continue to work as general manager.
So what about this, the legitimate, what do you call it? Legitimate
Expectation.
expectation.
Yes, Lordship.
See, it's not a kind of rule or something like that. You have been made a promise and allowed you to act on, and thereafter they have gone back to their promises. Otherwise, there's no question of invoking the doctrine of legitimate expectation. There was a certain policy of the company.
Yes, Lordship.
To give you some incentive, employees for a particular period.
Yes.
To a particular, where they are, as in when they're posted in a particular place. They have been granted.
Yes.
Subsequently, they have, unless you show that you cannot have a different policy, then to give a policy which provides you incentive. And unless you say that they don't have an authority to have their own policy, how can you say that? I mean, there's a question of legitimate expectation.
No, Lordship, the abrupt withdrawal of the promotion without any due process.
No, based on this thing, based on the, objection of the audit.
And it defeats my legitimate expectation.
And it's just an incentive
to
those employees who have been posted in a hard place like Arunachal and other Northeast state. And you have your own different promotion policy. Your promotion has to be on that. When you are posted, I think you'll get you have already availed the benefits in the post while serving here.
Yes.
The incentives, consequential financial, whatever benefits. Right?
Yes, right.
So your promotion has to be as per the promotion policy, regular promotion. It's just an incentive on being posted in the hard places like Arunachal and Northeastern states. And finally, on the objection, they realized that no, it's not possible to give this incentive.
And
so they have withdrawn it.
I was continuously serving.
They have
under the scheme.
The authorities has not withdrawn your permission from the, that incentive, from the date of providing you incentive. That is from the date of withdrawal of the policy circular, right?
Yes.
I don't see any.
And as of now, the petitioner is transferred and the company is also winding up, my lord. Its operation, my lord, here. They are going back.
But still they are working, Lordship.
Winding up is something different. That will consequently will follow.
Authorities might have been handed over, but they are still working.
Not in Arunachal Pradesh.
Yes. So, Lordship, my most humble prayer, that is to set aside and quash the impugned office order of 11/7/2025 issued by the GM of the respondent company, insofar as it reverts me, the petitioner, from the post of GM to DGM.
Okay.
Then Also, Lordship, also my prayer is that to direct the respondent to restore the petitioner, that is me, to the post of GM, HR, with all consequential service benefits, Lordship. And also most humble prayer is that to declare this.
Without service benefits, consequential, without or with?
No, with service benefits, Lordship.
Okay, we'll see. Pass the order. Had MS?
As Medhi, Lordship.
S. Medhi, Learned Counsel for the petition. And also had Mr. D. Suki, Learned Counsel for the
4 to 9, madam.
respondent number 4 to 9. Who else? 2. He's 1.
3, madam.
Why they have been made party unnecessary? Anyway, then serially you right. You are 1. You are 1.
3, madam.
Which one?
One is Union of India.
You say P. Sangeeta for respondent number 2 and 3. You are 3.
Madam.
And 4, huh? No need to. Union is also not that relevant.
No, my lord.
No need for respondent number 1. Union of India. Huh? Despite service of notice. I'll pass the order.
Man.
Deeply obliged, Lordship.
Item number 32, Lordship. 32 is there?
It's over.
Okay.
Time.
Yeah, oh, yes.
Yes. Huh?
He's in middle of
So when? In that case?
Possible today, for tomorrow.
Tomorrow it's not possible. After 1 week. You just write. It is submitted by Mr. M. Tasso, Learned Counsel for the petitioner. Learned Counsel appearing on behalf of Mr. Your name is there?
No, my name is.
Appearing on behalf of the Learned Senior Counsel, Mr. R. Sekia. That is senior Mr. That R. Sekia, Senior Counsel is engaged in some other court. Therefore, press for listing of the matter on after a week.